swearing the jury in, dismissing them, sending them to deliberate on this case. Let's bring in NBC News correspondent Emilie Ikeda. She was inside the courtroom. Emilie, talk to us about what you heard in terms of the different demeanor, the different tone at some points between the defense and the prosecution as they were speaking to the jury.
Hey there, Allison. Well, the fate of Lindsay Clancy now in the jury's hands following a highly anticipated morning in court. And you can really get the sense of that well before those closing arguments even got underway this morning. There was a massive line outside of the courthouse hours before court even opened, including members of the public who have traveled from out of state into the region, just fascinated by this case. Also members of the media. You might be able to make out a fraction of the media presence that has been on the ground here throughout the week and in the weeks ahead of time because of a possible press conference coming out of closing arguments today. Going inside the courtroom just to paint you a picture of what it was like, what the cameras weren't necessarily showing. The jury came in. They seemed a little bit more dressed up today, and they were locked in. It started with the jury instructions. They were listening to the judge. They had printed out sheets of the jury instructions talking about the difference between first-degree murder, second-degree murder, and then also manslaughter. And then they moved into the closing arguments. As you mentioned, the defense had started, and then the prosecution followed, both taking more than 50 minutes long. I will note we did hear Lindsay Clancy speak once, and that was when the judge had come in and said, "Good morning." She said, "Good morning, Your Honor." And she was looking straightforward, largely expressionless. But then when we started hearing the judge describe the first-degree murder, second-degree murder, I was sitting several rows behind her, and you could see her shoulders start to shake, almost vibrate. You could see her reach for tissues, wiping her face. At some points, her head in her hands, and Kevin Reddington, her defense attorney, even grabbing her hand at one point. She also got very emotional at one point during the prosecution's closing arguments, as the prosecutor was describing in detail, harrowing detail, the strangulation of her children. As for the jurors, they also showed a little bit of emotion. Several of the jurors during the defense's closing arguments, I saw a couple of people wipe their eyes, which what appeared to be tears, as they were describing some of what led up and what Lindsay Clancy was going through. Another notable thing, Ellison, I thought was notable was just the sheer number of props that the defense had pulled out during his closing arguments. He had poster boards of social media posts, pictures. He had a bag of medication that she had been prescribed in the weeks and months leading up to it. Also journals. At one point, the prosecution also grabbing a journal in this widely watched case. And we have seen people outside of the courthouse as well, demonstrations in the weeks leading up to this, but not much of a presence today. But again, some people following the case did attend inside the court to see these closing arguments, Allison.
Emilie, remind us the makeup of the jury here. We briefly showed on screen there how they break down in terms of gender. Take us through who this jury is.
Just limited information that we have about the jury right now, but initially we saw 12 women and 6 men. It was a few women that I saw who had been wiping tears from their eyes during some of the closing arguments, but they will have to determine whether Lindsay Clancy should be criminally responsible for killing her 3 young children 3 years ago. They have several options that they could convict her on if they're not convinced by the insanity defense: first-degree murder, second-degree murder, and after a push from the defense yesterday, also manslaughter will be on there as well, Ellison.
All right. Danny Cevallos, let's bring you back in here in terms of the options. This jury, you have 12 women, 6 men, 18 jurors, and all 6 of them alternates. They are considering first-degree murder, second-degree murder, now manslaughter, as well as the option of not criminally responsible. First-degree murder potentially would be life without parole if she is convicted on that. Second-degree could potentially also be life, but parole would be possible. Not criminally responsible would mean committed to a state psychiatric hospital, correct?
Yes, committed to a facility, and that's a separate finding that they have to make. And I can't stress enough that Massachusetts requires the prosecution ordinarily, especially in a world post-Reagan attempted assassination with John Hinckley, the history of the insanity defense, and we'll just call it the insanity defense for now, is that that generally post the 80s, states and including the federal government tightened up the insanity defense. It was perceived as too lenient. Massachusetts remains one of those jurisdictions where the defense is heavily in the defense's favor. An affirmative defense normally means the defendant has the burden to prove it. In Massachusetts, that's flipped. And the defense should and did make much of this in the closing. It is the prosecution, the Commonwealth's burden, not ours, to prove beyond a reasonable doubt that she suffered from a mental illness or defect and that mental illness or defect left her substantially unable to appreciate either the wrongfulness or conform her conduct to the law. I know it's a mouthful, but the bottom line is this. The defense really can argue that if you find that the experts and the medical providers had it at a tie absolutely goes to the defense, because that means the government did not prove their case beyond a reasonable doubt.
Remind us of how this works in Massachusetts, because oftentimes in some states, if you see a defense putting on an affirmative defense saying, yes, they did do this, but they should not be considered criminally responsible because of something like a mental health condition. Oftentimes in some states, the burden of proof does somewhat shift from the prosecution to the defense,
Sure.
where they have to prove that there was something happening that makes them not criminally responsible. That's not the case here, right? We even heard the judge reminding the jury the burden of proof is solely with the Commonwealth, with prosecutors here.
That's right. And the defense knows that the jury's going to get that instruction, and they know it's a good one for them. And that's why defendants, when there's an instruction we like, the defense counsel often says, listen to the judge. The judge will tell you, and then they'll say those exact same words, and they resonate. So one of the things that's a real wrinkle that came in just the last couple of days isn't so much the insanity defense. In Massachusetts, they call it criminal responsibility. We'll probably go back and forth between using the word insanity. But what's really interesting is the addition of the manslaughter option. This is why this is so compelling. And I've been in this situation. What do you do as a defense attorney? Do you want a lesser included offense instruction for the jury? Here's why you might not. If you think your case is going in very well as a defendant, then you want to put the jury to an all or nothing decision. Either this is murder, the worst of the worst, or it's an acquittal. The challenge now with a manslaughter option is it gives the jury a lesser hook to hang their proverbial hat on. So will they look to that as an option? Oh, we don't think it was murder, but now we have this manslaughter option. And it can cut both ways, both for the defense and against the defense. The opposite example is if you're the defense counsel, you think this case is going horrible. We are in big trouble. Then you do want that lesser included offense option. Here, the jury has a couple different choices. They can find the Commonwealth didn't disprove insanity or lack of criminal responsibility, or they can find that she committed manslaughter, something with the intent that is below that of the general specific intent to kill.
We thank you for watching. And remember, stay updated on breaking news and top stories on the NBC News app or watch live on our YouTube channel.